Your smartphone is essentially a portable digital diary that knows more about your private life than your closest friends or even your spouse. You probably carry it within 5 feet of you nearly 24 hours a day. And like many Americans, you might even take it into the bathroom or use it in the shower. Most people assume that if the police stop them on the street or pull them over for a traffic violation, their phone is as private as a locked desk drawer in their home. But here is the surprising legal fact. While a 2014 Supreme Court ruling makes your phone's data more protected than the wallet in your pocket, there are specific legal black holes, like the U.S. border, where those same privacy rights can almost completely vanish. There is a common misconception that if you are arrested, the police can automatically search everything on your person, including your digital files, as part of a search incident to arrest. Today, we are revealing why that is wrong, how the law treats your digital movements like a virtual panopticon, and the one mistake involving Face ID that could allow the government to bypass your constitutional protections entirely. For decades, the law followed a simple rule. If you were arrested, the police could search you and the area within your reach to ensure you didn't have a weapon or evidence you could destroy. This changed forever with a landmark 2014 case called Riley versus California. The Supreme Court unanimously ruled that smartphones are fundamentally different from physical objects, like a pack of cigarettes or a wallet. Chief Justice Roberts famously noted that these devices hold the privacies of life, and searching one is often more intrusive than searching every room in your house. Because a phone can store years of messages, medical records, and bank statements, the court decided that the police must generally get a warrant before they can touch your data, even if you are already in handcuffs. However, there is a massive catch you need to know about. The law moves much slower than technology. While the police might need a warrant to look at the photos on your phone, they have spent years using a third-party loophole to track where you have been without one. This brings us to the 2018 case of Carpenter versus United States. In that case, the FBI used cell phone tower records to get nearly 13,000 location points on a suspect over 127 days, an average of 101 data points per day. They didn't get a warrant. They just asked the wireless carrier for the records. The Supreme Court eventually stepped in, ruling that this kind of near-perfect surveillance was a Fourth Amendment search that requires a warrant because Americans have a reasonable expectation of privacy in the whole of their physical movements. But does this protection apply if the police only track you for a few hours? This was the curiosity gap left open until the very recent 2026 decision in Chatrie versus United States. In that case, police used a geofence warrant to ask Google for the data of every phone within a 150-meter radius of a bank robbery during a 2-hour window. The government argued that tracking someone for just 2 hours doesn't reveal the intimate details of their life, so a warrant shouldn't be necessary. The court disagreed, concluding that even short-term digital tracking is a search because the government shouldn't have access to a virtual panopticon where they can retrospectively see where anyone was at any time. Warning, even with these strong court rulings, your rights change the moment you arrive at a U.S. port of entry or airport. Under a long-standing exception to the Fourth Amendment, Customs and Border Protection, CBP, has the authority to search you and your belongings without a warrant. In January 2026, the government updated its policies to include not just your phone, but your smartwatch, your tablet, and even your car's infotainment system. While agents are not supposed to access data that lives purely in the cloud, they can conduct a basic search by manually scrolling through your device at their own discretion with no suspicion of a crime required. This brings us to a critical legal distinction: biometrics versus passcodes. Many people use Face ID or fingerprint recognition for convenience, but this could be a major privacy mistake in a police interaction. Some courts have ruled that while the police cannot force you to reveal a memorized passcode, they can legally compel you to provide a biometric lock, meaning an agent could hold your phone up to your face to unlock it without your consent. Legal experts recommend temporarily disabling Face ID or Touch ID before traveling through a border or entering a situation where you might interact with law enforcement. Another dangerous myth is the idea that if you have nothing to hide, you should just consent to a search. Legal educators warn that consent must be given freely and knowingly. If you say, "Go ahead," or "I have nothing illegal in here," you have effectively handed over your constitutional shield. Once you consent, it becomes nearly impossible to challenge the search later in court, and the police can look through everything, not just what they originally said they were looking for. If you want to protect your privacy, you should remain calm and clearly state, "I do not consent to a search of my phone." There is also the exigent circumstances exception, which acts as a legal emergency brake for the police. If officers have a legitimate reason to believe there is an imminent danger to life, like a bomb threat or a kidnapping, or if they believe you are about to remotely wipe the data from your phone to destroy evidence, they may be able to search the device without waiting for a warrant. Courts will review these cases later, but in the heat of the moment, an ongoing emergency can override your typical privacy protections. Finally, be aware of the plain view doctrine. Originally, this meant that if an officer was standing in your living room with a valid warrant to find a stolen TV and saw a bag of illegal drugs sitting on the coffee table, they could seize the drugs. In the digital world, law enforcement tries to use this to expand searches. If they have a warrant to look at your text messages and they happen to see an incriminating photo while scrolling, they may claim it was in plain view. However, digital forensics experts argue that files aren't like objects in a room. An examiner usually has to intentionally open a specific folder or app to see what's inside, which means plain view should rarely happen by accident on a smartphone. To summarize your key legal takeaways. First, the Supreme Court has established that your phone is a virtual warehouse of your most intimate life, and police generally need a warrant to search it. Second, this warrant requirement now covers your historical location data and geofence searches, even for short periods. Third, your rights are significantly reduced at international borders where basic manual searches are often permitted without a warrant. Fourth, passcodes generally offer stronger legal protection than Face ID or fingerprints, which agents might be able to compel you to use. Fifth, never rely on the "nothing to hide" myth. Clearly stating that you do not consent is your most powerful tool in protecting your data. Thanks for watching the legal lecture. If you found this helpful, subscribe for a new video every week and leave any questions in the comments. See you next time.